Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Oh my gosh, y'all. We are here with breaking news. Today even gets better.
Breaking news.
We have an emergency hearing for the Black Swan case to, one, dismiss the judge, and two, delay the case. Let's get into it. Let's might as well just hop on in because it's going to be good. All right, here we go.
Continuance. I'm not aware of any additional motions that we filed. And I have an oral tennis motion that I'm going to make.
All right, I have your motion to continue.
I think we've articulated it well in the motion, Your Honor. I don't see any reason to go into the specifics any deeper.
Oh, we do.
We delineated in a nutshell, though. Given the recent rulings by the court, especially as it relates to the deprivation of Mr. O'Keefe at counsel table, and what I understand is now an issue about even having his laptop connected to an HDMI cable. Apparently, court services will not allow that because it extends beyond counsel table, and they've deemed it a tripping hazard.
Tape
we
it
have
down.
a lot of our court services to extend the cable, but apparently not. So, yes.
And there was no matter pending before me. There was a bunch of emails going back and forth, but I don't rule on emails, sir.
Judge, it's just so we're clear. It's
just
my
duct
position.
tape.
This is not an issue that should be dignified by a formal motion. Connecting my assistant's laptop to assist me in defending Ms. Benefield and requiring a formal motion for something so perfunctory is an indication of just how difficult the court has sought to make this for the defense from day one. That's my position, Your Honor, respectfully.
Respectfully.
I haven't even been mentioned other than the fact my judicial assistant was copied on some emails going back and forth about this issue. Did you just expect me to jump in?
Yes, in fact, I did.
Okay, well, that would be inappropriate. So tell me where you want to run the cable from and what the problem is.
We need the laptop connected. As the court well knows, Mr. O'Keefe has not been permitted to sit at counsel table, so the cable needs to extend to this back bench for Mr. O'Keefe, and court services.
To where?
Where?
To your table?
To the back bench. It needs to go past our table.
It must be really spicy for them to miss audio. What? Really? I jumped on for no audio? Okay, audio comes back. Good. Y'all, that judge must be really mad. She looks almost Amish. Mennonite. Sitting there. Why is this portion?
Emailed your JA to say, hey, can we talk about it Monday? So if it's just to hit the button because Mr. Taylor is incapable, then I would not have an objection.
Okay.
Thank you.
Yeah. Just run the cable. We'll get duct tape. In fact,
Yeah, and as the court knows, Mr. O'Keefe has never practiced
let me
law
throw you the
in
duct
Your Honor's
tape.
court, so I don't quite understand the state's position, but he's going to hit the button.
all right. The great motion of the cable is resolved.
Thank you.
And we can move on to the,
Are you kidding me?
Deprived of that assistance. So we would have to go back through a lot of our exhibits, and as I've articulated in our motion, the
Oh,
reasons
please.
why we think continuance is appropriate. That's our emergency motion to continue.
thank you. State.
Judge, we object, and we find that there's no valid reason for a continuance.
All right. The question I have is.
It was 15 minutes ago.
Late last
Oh, I
week, I
heard.
don't know if it was Thursday or Friday, I received a
This is not this morning.
motion. I don't know if I have it in my pile. Under
I don't know.
90.702 Daubert for the defendant's expert. And I don't remember his name, but it was referenced last week.
Okay, this video hit 15 minutes ago. I don't think this is the full morning. All of the delivery jury, the jury selection and all that was this morning. This is an emergency motion.
So,
Ferris. Yes, sir.
all right, typically that would be heard prior to trial. Sufficient time for both sides.
So it
to
was
have a
earlier
ruling and
today.
Be prepared.
It just
I
said
understand,
happened
Judge.
15 minutes
That
ago.
that was a response really to what happened on Tuesday, because we thought we had handled it the appropriate way, and evidently we had not. And so I was trying to correct it. I did put in the motion that I understand it's normally a pretrial motion, but in order to not have Mr. Ferris have to come here and try to handle it this morning when we're trying to pick a jury, we have no objection to just having it basically Thursday, whatever morning he would be here. Because the state has objections to his testimony on many grounds, and we have a fear that it's going to be a situation where we're objecting, which is going to be awful for the jury and for the court. It's going to delay things. So that was our hopes, that we could have
I'm gonna
some
let
kind
you
of
listen. I'll be
hearing
right.
when it's Your Honors thinks it's appropriate to discuss whether or not his expertise as a domestic violence expert qualifies him to testify during this trial.
All right.
And, I'm sorry. Sorry, Judge. I left out. Our other thought was some of it depends on what comes out during trial. And so it's kind of hard to handle it pre-trial. As we discussed last week, some of the other things are very difficult, and which is the other reason we thought it might be more appropriately heard right before he was going to testify.
All right.
Thank you, Judge.
The procedural hurdle that raises is going to be if I deny the state's Daubert challenge, or whatever the ruling may be, but it's against the state, you certainly have the right to appeal. And I think the problem would be if we're in the middle of trial and it's late this week or sometime early next week, the difficulties that could raise.
We understand, Judge. I think we're past that point we're at the point of we're ready for this trial to go and to get it through. So,
Okay.
thank you.
All right. Yes, sir. Any final thoughts?
Well, as I raised earlier, not
Yeah.
only did the court issue a cutoff date for motions, but both sides signed off on that cutoff date, and that cutoff date is long past. So this request for a Daubert hearing is beyond tardy, and I think the court should deny it. It's as simple as that.
Well, we'll cross that bridge when we come to it. I think both parties were filing motions and asking for hearing time well past the cutoff. All right, in considering the motion to continue, we start with the, although not sure all of these factors or elements were argued by both sides. Whether the denial of the continuance creates an injustice for the movement, whether the cause for the request was unforeseeable, whether the cause for the request was dilatory practices, and whether the opposing party would suffer any prejudice, injustice, or convenience. Looking at the Fleming factors, I don't need to make a great deal of factual findings. But the main thrust, as I'm understanding it from the motion and the argument today, is the issue of Mr. O'Keefe sitting at council table. I think I've made sufficient allowances for him to be near and present, but not at council table. I don't find that there's an injustice. Unforeseeable or unforeseeability. Certainly, I don't think this is an unforeseeable ruling based upon the scant case law that's available and the fact it's a matter of discretion for the trial court. I think certainly both sides have noticed and can expect as experienced attorneys that sometimes the courts rule favorably to you and sometimes they rule against your position. And if there's issues that need to be brought up before the court and well in advance of trial, they should be. But when issues are brought before me by motion, I rule on them, and I have not been dilatory in my rulings. And as opposed to the other side, certainly this case has been pending since around September of 2020. It's now July of 2024. I think the state has every right to and is ready to go to trial. I think both sides are and should be ready at this point. There's been more than sufficient time for preparation. Again, the incident complained of and the information happened in September of 2020. I don't find that there's any prejudice from the rulings that I've made regarding Mr. O'Keefe and where he's sitting. So in addressing the Fleming factors and the McKay factors based on the Uptain factors, I will deny the motion to continue.
Oh, okay, Paula. Well, I don't mean to mislead. I just saw where it said on another live emergency or urgent or something like that, just posted 15 minutes ago. So anyway, it's news to me. I apologize. Oh, I feel like an idiot. Oh well.
All right. Was that all of your
News to me.
motions? Or was
No,
there?
I have two left, Your Honor. The first one is pretty small. and
Get you off the
simple.
bench.
I wonder if the court would have any objection if we bring in to assist with the mechanics of this trial, a very small portable table so that Mr. O'Keefe can have something to put his laptop on.
No spoilers.
We can put it back there.
How big of a table?
Like a little
TV tray.
Table, Your Honor.
Like a dinner table or a TV tray?
Yeah, the equivalent of like a TV tray.
If it's the size of a TV tray, I think that'll be fine because it'll just sit right in front of him and that shouldn't block ingress or egress from that side.
Very good. Thank you, Judge. My last motion, if I may.
Yes, sir.
To get rid of you.
Your Honor, this is a motion for the court to voluntarily disqualify itself. And if the court would be kind enough to allow me to make my record, I'd appreciate it. This is an appeal
Nope.
to the court's sense of honor, integrity, and to the oath that the court took when sworn into the office that it now holds to support and defend the Constitution of the United States, specifically the Sixth Amendment right to a fair trial, and the Florida Constitution's Due Process Clause in Article 1, Section 9.
I know,
of the
right,
Florida
Ronnie?
Constitution. The court's order of September 18, 2023, denying Ms. Benefield's request for judicial immunity. On page 26 in the third paragraph, Your Honor, reads as follows. Considering the totality of the competent and substantial evidence admitted during the Stand Your Ground hearing, the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. Now, had the court issued a neutral order that would have or should have read that the state has met its burden by clear and convincing evidence for purposes of the request for judicial immunity and the defendant's motion is denied, it would have gone on and said whether the shooting was justified is a question of fact to be properly submitted to a jury at the trial of this matter. How can Ms. Benefield possibly receive a fair trial with the conclusion that the court reached in that order? Make no mistake, that order says Ms. Benefield is guilty of the crime with which she is charged. Ironically, we're here this morning to select jurors, and the court is going to instruct them that they are to presume Ms. Benefield innocent of the charges against her. How in the world can we expect that of the jury when the court cannot extend that presumption and honor it based upon what the court's words, not ours, what the court wrote in its order?
Justice.
That conclusion specifically, Judge White, help explain why at this stage the court has, among other things, quashed
She looks like a Mennonite.
witness subpoenas and told the defense they can prove it some other way when it's our case and our right to a fair trial, and we decide the best manner in which to present our case within the rules of evidence and criminal procedure. Why, Your Honor, has denied Jack O'Keefe from assisting me in the trial of this case, and why the court at the last hearing that we had on its own suggested to the court that perhaps the right action on behalf of the court would be to file, on behalf of the state, would be to file a Daubert challenge. The record of that hearing will specifically note that the defense requested a Daubert challenge in response to the state's motion. The state never did. The court suggested that to the state at that hearing, and lo and behold, the very next day, the state filed a motion requesting a Daubert challenge. As the court knows, according to Florida Statute 3810, you can move to recuse the court based upon demonstrated bias or prejudice. Rule 2.330 of the Florida Rules of General Practice in Judicial Administration likewise
She murdered
provides
him.
for the disqualification of the trial judge. Now, here's the problem.
That judge ain't even listening.
It's imposed in the Rules of Judicial Administration and the case law. And frankly, I missed it. And I missed it because at the time the court entered its order,
That judge is writing his response. He ain't even paying attention.
It was quite some time following the stand your ground hearing, and we were not only focused on filing the appeal, but by the time the appellate court acted and the second DCA denied our motion, I had just missed it. And I take responsibility for that.
Oops.
That, therefore, is why I asked the court, based on its order, to voluntarily take the high road and step aside voluntarily and give, in doing so, objective recognition to the oath Your Honor took to support and defend our constitutions, which includes, as the court knows, an opportunity for a fair trial by an accused, by an impartial jurist. So,
Yeah, she doesn't.
I asked the court to do the right thing.
And it's going to say, nope.
There's no getting
Look at
around what the court wrote in that order.
Would you like to be heard?
Judge, I would just like to say that the stand your ground hearing The court is the trier of fact, and the court does need to make factual findings. And the fact that that is being held against the court, I think, is quite unfair. The court is not the trier of fact in a jury trial. The jury is. There has been nothing in the court's rulings to show any animus towards this defendant. I quite frankly think this is the defendant's MO. This is what she does. When someone doesn't agree with her or a judge does not agree with her, she does a
Are you
motion to
praying?
recuse.
Is that why you're standing
I feel
that
like
way?
this should have been done a year ago if it was going to be done.
Attitude much?
It was only done at this late time because the
Attitude
court's
much?
rulings did not go in the defense's favor, and this is their last ditch effort.
Yeah.
The state would also say, if the court was inclined to grant this, that we just flip-flop judges right now and start this trial this morning. Thank you.
All right, thank you.
Ooh.
Any final thoughts on your motion?
I'm sorry, Your Honor?
Any final thoughts on your motion?
No, sir.
All right, thank you very much.
Really? Which one's the
All
daughter?
right, so the jury
I'm going to go back.
questionnaires,
Court's
And
rulings
look.
did
Which one's the daughter? That little girl there? This one right here in the yellow? Wait, whoa. Is she on the left-hand side?
not go in the defense
You skim back a little.
held against the court, I think, is quite unfair.
The one on the left?
The court is not the trier of fact in a jury trial. The jury is. There has been nothing in the court's rulings to show any animus towards this defendant. I quite frankly think this is the defendant's.
Wow. Okay.
Tracy,
Okay. We'll
any
start there. I
final
got
thoughts on your motion?
that one. Yep.
I'm sorry, Your Honor?
Any final thoughts on your motion?
No, sir.
All right, thank you very much. All right, so the jury questionnaires, we don't have them yet?
He's not even responding. He didn't even respond.
All right, so they're going to be sending up the questionnaires. We're going to get them about 10, 15 minutes, I would think, according to the clerk. And we are going to have the panel of 70. So for those of you who are here in the courtroom, the veneer panel that we're going to bring up is going to take both sides of the courtroom. So what I've done is I've asked court administration to open up another courtroom that will have audio
Nope.
or video so you can listen in and it'll be made available. And that's courtroom 5A. 5A. So fifth floor, courtroom A. In fact, it's basically just right down below where we are right now
Basically, he's denying.
of witnesses you expect to call. So when I'm introducing everybody, tips and knowledge about the case.
Wow, y'all. He didn't even acknowledge it. I'm like, whoa. Dude, that might be good. Okay, guys, I'm sorry for the emergency thing because it said it on another thing. So I apologize, but this is something we didn't cover today. So apparently all the motions were dealt with. I still don't understand what the problem is by having his assistant there at the table with him. But he can sit kind of behind him with the TV tray. Okay, fine. Duct tape the cable down. Fine. I don't understand what was going on with all that. To me, that was just a bunch of BS. She's all over TikTok. Who's she? The daughter or the defendant? While we're here, I might as well show you. We've got some new things. Excuse me, I swallowed wrong. I got something special. Y'all watch. July has been an amazing month. And to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. What do y'all think? Oh, yeah. Well, it's not unusual for the judge to not give a decision on a motion. However, they didn't argue the motion. They were supposed to do that today. It was our understanding that the motions were going to be dealt with today. So the motions were already entered prior to today. So what the heck was today all about other than scheduling the next trial? Why are you doing that? You need to hear the motions and see whether or not the trial is going to be denied or whether you're going to have a trial or not. And I'm suspecting that she already knows she's going to deny the motions, but she's got to allow it. So she's going to allow the speaking in motions August 9th, and then the trial is going to go on January 27th. Yep. Just wrote it down. Scheduling hearing. She could have heard it. Y'all, she could have heard it. She could have. I don't, she said she wanted to get this dealt with fast. And then it just frustrates me. I'm ready for this to be done. Dun, dun, dun. Okay, y'all. Please come back and join us tomorrow morning. We are going to have an interesting day. I'll be starting at 7:30 Central. I'll be yawning and having a bunch of coffee, but I'm going to be here. I want y'all. Should I show up in some PJs? Oh my gosh, don't scare me. We've had an echo problem. Thank God, Paula, I didn't have that problem. Oh, no, no echo. Don't need echo, don't want echo. We're not doing echo. Echo. I had an echo thing on my switch thing here, and I took it off. It was driving me crazy. Do I still have it? No. Nope. Got rid of it. Okay, so I think I'm going to show up at least for the first half of the day, in a comfy shirt that says coffee necessary, in a pair of leggings or pajama bottoms, and be all comfy. Y'all come in comfy tomorrow. It's going to be a long day. Long day. So, with that, we will see you tomorrow. And thank you for hopping on again. Till next time. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing.